Good afternoon, Your Honor. Benjamin McAllen, Wilkie Farr, and Gallagher on behalf of the Ad Hoc Subrogation Group. And I have with me today Margot Mooney of my office, who will also be handling the CAL FIRE dispute.
Okay, great.
Good afternoon, Your Honor. Paul Pascuzzi, Felderstein Fitzgerald Willoughby Pascuzzi, co-counsel with the California Attorney General's Office for the California State Agencies, including CAL FIRE. Also in the courtroom, Your Honor, is Tracy Windsor from the Attorney General's Office, who will be handling the CAL FIRE discovery issue. And, Your Honor, if it's okay with the court, I'd like to update the court on the status of the government entity claims.
Yes, we'll get to that in just a moment.
Thank you.
Your Honor, Sarah Winslow for the United States.
Oh, okay. Yes.
Good afternoon, Your Honor. Kevin Orsini, Cravat, Swain & Moore on behalf of PG&E, and also here with me today is Tobias Keller from Keller Benvenuti for PG&E.
All right. Well, why don't we, Mr. Orsini and Mr. Julian, let's just, before I get to the other things, check in generally. Is there anything you two need to add or want to raise?
Yes, Your Honor. Mr. Orsini and I intend to file Judge Montali's decision on the inverse ruling. Judge Montali adopted California's law on inverse.
Oh, I have it. You
have it?
You don't need to file it.
Okay. You have it. And that's all we have to report.
Okay. Everything else is moving along?
Everything is.
It is, Your Honor.
Dates are working out?
Yes.
Okay. What about that custodian issue that we talked about? You got that resolved?
We're working through it, Your Honor. We filed a stipulation last week with respect to how we were going to deal with the privilege issues. There are some issues that the TCC has raised, some concerns they had about some of the search terms. We're working through that. In fact, I think my team just sent a response as we were about to stand up here. I expect we're going to be able to resolve any remaining disputed issues, but Ms. Morris might have something to add on that front.
Okay. All right. Yes, Ms. Morris.
Nothing to add other than I have not yet had a chance to review the email that was sent to me at the start of these proceedings, and so I'll reserve the right to come back to you if we can't work through those issues, but my hope is that we will be able to.
All right. Let's do a little forward planning. So I'm happy to see you in 2 weeks, but I know that's getting into travel time. Do you want to cancel that, or do you want to keep it on calendar? You want to keep it on calendar? Okay.
I agree with that. If we collectively have the view once we get closer to it that we don't need it with everything else going on, we can, of course,
just let me know by Friday noon by Friday.
The preceding Friday. Okay.
Okay, that'd be good. Okay. All right, let's take up the discovery issues, docket number 241 and 244. Who's going to do CAL FIRE?
I'll start, and then I think David has a few things he wanted to. Right.
But who's representing CAL FIRE?
Good afternoon, Your Honor. Tracy Windsor here for CAL FIRE from the California Attorney General.
All right, great. Okay, you two should make your appearances again.
Margot Mooney on behalf of the Ad Hoc Subrogation Group.
Okay, you need to speak up just a little bit. All right. Go ahead.
And David Rice for the TCC.
Okay, all right. Let's hear from CAL FIRE.
Good afternoon, Your Honor. Thank you. As we understand it, there have been calls back and forth today between the TCC and the Ad Hoc Subrogation Committee, and there's been some discussion of whether there can be a production, perhaps, of the investigation report in a redacted form. Those conversations, as we understand it, are ongoing. So at this time, CAL FIRE, as you have seen from our letter that we filed last Friday, we are in a posture where the prosecution team. Let me back up. I'm here today representing CAL FIRE as an independent California state agency, and there are a group of deputies who are liaisons to the Butte County District Attorney's Office that are involved with the criminal investigation. And so, to the extent I speak today, I speak on behalf of CAL FIRE and not on behalf of the criminal prosecution arm of the California Attorney General.
And they're not here today.
They are not, but I am privy to the communications, and so I am here to update you on those. And
but they're not here, and the Butte Butte County DA is not here either. Is that right?
That is correct, Your Honor. The meet and confer that is referenced in the letter from the TCC occurred between the TCC attorneys and the subrogation attorneys and the attorneys for CAL FIRE, one of whom you see standing before you today. And we have encouraged them on multiple occasions to speak to the prosecution team because, as we've indicated in our papers, the local enforcement agency, the Butte County District Attorney, is the part of the state of California that has control over the evidence and the information that they are seeking. So while CAL FIRE has custody certainly of its own report, its own photos, and some of the evidence, as they've indicated, some of the evidence is no longer in CAL FIRE's possession. So all of the information that they seek is very much subject to the control of that local law enforcement agency.
Well, let me ask you this. You actually read my mind a little bit. You have a final report, right? CAL FIRE has
CAL FIRE does, yes.
Okay, so that report's done and on a disk drive somewhere ready to be printed out, right?
It would probably be in several locations.
All right. And it sounds like you're amenable to producing it with maybe some redactions?
Well, and that's the piece where I can't speak. It's fluid, as I understand it. That is under discussion. And I think that's the direction things are moving, that the prosecution team has indicated willingness to produce it with redactions. We would ask that Your Honor wait and not make an order today and allow the parties to meet and confer regarding the extent of any redactions and attempt to resolve any issues that may arise in that regard.
Right. Is it Ms. Mooney? All right. What's your view on that? Do you want me to wait, or do you want me to do something today?
We are happy to meet and confer with the AG's office, and we have a follow-up call scheduled for tomorrow. But we do want to move quickly because of the looming deadline for the exchange of expert reports. And as we've laid out in our letter,
Let me ask you this. I've already tipped my hand. I think the report's probably producible. So you two work out redactions, all right? You should let me know by Thursday if you can't get it done, okay? But given that PG&E has acknowledged that the equipment caused the fire, although they dispute the legal implications of that, what is it you think the report's going to give you that you don't already know? So they're on the hook for saying, yes, as a literal matter, our equipment caused the fire.
the reports that we've seen for the other fires contain a lot of detail about the facts and circumstances surrounding each of the fires. Where there is an arborist, where there's a vegetation management issue, there'll be an arborist report that will have details on the trees. Here we would expect that there'll be a report about the condition of the Caribou Palermo line and the equipment that was involved. And looking to present the evidence to this court in an efficient manner, given the timeline that we are on, we think that the reports provide invaluable evidence to the court's consideration in assessing PG&E's likely liability.
All right. Mr. Rice, anything to add?
Yes, sir. The one point I just want to add is that, given the crucial importance of the report itself and also of the campfire to...
Why is it crucial, though? I mean, if PG&E said, yes, we're on the hook, so to speak, what more do you need?
Well, given the fact that the campfire is responsible for 75% of the total damages in the claims proceeding, we need to know for ourselves. We need to do our diligence and make sure that that the victims here and our clients have the access to the most possible evidence so we can present our case in the best possible way. And I believe that having that report is a crucial part of that.
All right. So report sounds fine, but the physical evidence, I don't really see. What do you need that for? I'm more skeptical that that's necessary. I'm not going to look at it. I mean, remember, we're estimating liability. I'm not making any determinations as a final matter. So why do you need to see the physical evidence?
Heard from our experts that it would be helpful to them in putting together their reports to be able to see the evidence itself, possibly submit it to non-destructive testing, and or to see photos, and we are also hoping for depositions to
Oh,
understand.
we'll get to depositions in a moment. All right. Well, what about the physical evidence?
Well, Your Honor, I very much agree with the court. This is an estimation proceeding, and Your Honor has indicated that liability will be truncated. I've personally sat through a deposition of a PG&E lineman that inspected that line in 2016 for replacement of the connectors, and the TCC noticed that deposition and examined that lineman about what he saw. They showed him pictures of the broken hook, and he concurred that that was not in workmanlike condition and needed to be replaced. They showed him pictures of the exemplar hook that you see in their letter on the left-hand side, and he concurred under my examination and much more by the TCC that the groove that you see in that exemplar hook indicates that it should have been replaced.
Is it true that those hooks are 100 years old?
I'm not privy to that. Excuse me, that fact, Your Honor, but it is my understanding that you can see rust and wear and corrosion on them just from the photographs. So I would very much concur with Your Honor that the examination of the physical evidence may be of limited utility to this court and what the court needs to accomplish to evaluate these claims.
So I think the physical evidence is a step too far away, and I am a little concerned that it is unique. The report is not, but the physical evidence is unique. And if it's going to be used in a criminal prosecution, I think there are chain of custody issues and preservation issues that are important. So I'm not persuaded that we need to do that now. So the report, yes. If you want to work out redactions, you have till Thursday to let me know. And if you can't do it, I'm not going to read the report and line edit it for you, but if you can't, you need to tell me what the general categories are. The burden's going to be on CAL FIRE. If there's something you want to keep out, you're going to need to tell me what it is you want to keep out and what the necessity for that is and why attorney's eyes only designation under the protective order would not be sufficient to preserve any confidentialities. Physical evidence is a tentative no, meaning if you read the report and there is a compelling need, I want to underscore compelling to see the physical evidence, I will consider it, but it's unlikely that's going to win. So you're going to have to come in with something good, all right? Something powerful and persuasive if you want it. And I think one deposition seems perfectly appropriate, 30B6 witness. Is that what you had in mind, Ms. Mooney?
That is what we had in mind, as long as it's somebody who is informed and prepared to speak to the issues.
Yeah, ideally, the chief investigator or someone who's in an ideal situation to be able to speak to the report and the details, collection processes, that sort of thing.
Okay, well, you can do a 30B6 and don't go nuts with the topic. It's the contents of the report and maybe how it was prepared and something along those lines. But it shouldn't be more than, I'm not tying your hands, but I would expect it not to be more than somewhere between 4 to 5 topics in a 30B6. Okay? All right. Anything else I can help you with today?
Your Honor, I just want to make sure I understand the court's ruling regarding the deposition. The last that we had met and conferred about this, the attorneys were looking for a recipient deposition only to show some photos that they had, like the ones here, and ask what the condition was when someone saw it. As I understand it, we're talking now more about a deposition to lay the foundation for the report as an official record.
Oh, no, I'm not worried about it. The letter 241, docket 241 says 2 depositions about, from CAL FIRE employees for people knowledgeable about the investigation. I'm letting them have 1. And in order to make life easy, they can do it as a 30B6 deposition and just tell you what topics they'd like to cover. Okay? And it shouldn't be more than 4 or 5. Okay? All right. That's it for these 2 things? Okay, good. Okay.
Your Honor.
All right. I issued the order on the restrictions on the use of the fire victim testimony. You all have already agreed to ESI protocols. Anything else for today? Yes. Oh, yes.
Paul Pascuzzi, co-counsel with the Attorney General's Office for the California State Agencies. I just wanted to update you on the status of the government entity claims, Your Honor,
Yes.
which include the state agency claims and the Fed agency claims. We did file our pleading, and we filed a copy of it with this court last week, so you had an understanding of what was at issue there. The debtor's opposition is due this Thursday, and then our response is due on December 12th, and then the bankruptcy court will have a hearing on December 17th. So I'm anticipating that sometime around the 17th, we'll have some sort of indication from the bankruptcy court about what government fire claims are to be part of this estimation proceeding. And then we will meet and confer with the debtors regarding further scheduling and things like that, similar to the scheduling order that's already been issued from the tort
Okay,
committee.
well, if you know by the 17th, do you expect to hear that day, or do you know?
It's hard to tell, Your Honor. There are 42 claims for state agencies, about 8 different state agencies. I know the United States government, there's less claims, but we've conceded that 6 of them, mostly related to the campfire, are unliquidated, but 42 is what the debtor says, and we say 6. So.
All right, well, let's say you're here by the end of the year. I think in a moment of inattention, I may have said we'll do you after the February hearing, but I'd like to do you at the same time. So if you hear it by the end of the year, can you just kind of get on the same track with everybody else?
We will do our best, Your Honor, and actually we've been trying to get an agreed protective order with the debtor so that we can be part of the discovery and get the information and the discovery that's been produced. We're not quite there yet. I'm hoping very soon we will be.
What's the holdup?
The law enforcement exception and Public Records Act exception. The other protective order didn't deal with any governmental entity issues. So the ball right now is in the debtor's court. We're waiting to hear back from them. I'm hopeful we have that resolved.
What is the issue?
Your Honor, Public Records Act, Freedom of Information Act issues. If we get one, how do we deal with it? Also, law enforcement use of any information that we see we deal with on through the discovery. So we've got basically an amendment to the existing protective order that the debtor, and I believe speaking with the Weil Council, we're on the same page at, but I'm just waiting back to hear.
You're saying that if you get discovery from PG&E and a Public Records Act request, you may be required to produce that?
Exactly, Your Honor.
Even if it's under a protective order?
Yes, Your Honor. And it just outlines the procedures for us to give them notice so that they can come to court to get a protective order before we have to produce it under a Public Records Act exception. So it's simple stuff. We should be done with this. We've been feel like we've been slow played a little bit, but we don't have access to any of the discovery.
Slow played by who?
The debtors.
Oh.
And Your Honor, I will say that
come on up, Mr. Orsini.
The United States does have a protective order that's been entered by the bankruptcy court, and they've not been given access to discovery either. But we're told we will be given discovery. So,
what's the holdup?
Your Honor, I think, as Mr. Pascuzzi just mentioned, we had negotiated an amendment to the protective order for the federal government. There were a number of additional complications with respect to the state government entities. It's been in process. My understanding is we're pretty close to done. There hasn't been any slow playing. It's just with all of the balls in the air. I think this one is close to the finish line, but not quite there yet.
How about Wednesday? You get it done by Wednesday?
I would expect so.
Wednesday, okay. Get it done by Wednesday. I want to make sure the government entities are on the same program, so I don't want any unnecessary delays. All right?
Your Honor, we'll meet and confer with the debtor because we haven't disclosed witnesses and things like that because we don't know what claims are at issue yet. So we will do our best to get on the same.
Well, make it a rolling disclosure. I mean, don't wait till you know everything. Just as you know, disclose.
Okay.
And
we'll find a way to make it.
And then maybe this won't happen, but just let's bank on the probability that it will. In other words, you'll be here with me, and I don't want to have to start doing everything on February 1st. So let's just get it going now. Okay?
Thank you, Your Honor.
And get the order in place by Wednesday. Is that with me or with the bankruptcy court?
Bankruptcy court.
Okay. All right. Just get it on file with the bankruptcy court then by Wednesday. Okay. Anything else for today?
Not from us, Your Honor.
Anything else from anyone else? No? Okay. Thanks very much.